All right, you won't hear these words come out of my mouth often, but we have some good news coming out of the Supreme Court. Take a look at this. In a landmark privacy decision, the Supreme Court ruled 5-4 on Friday that police must get a warrant in order to obtain your cell phone's location data over an extended period of time. The decision is a major victory for privacy advocates who have long argued that the law has failed to keep pace with the amount of intrusive data we voluntarily hand over to private companies. Chief Justice John Roberts joined the liberal justices on the court, declaring that even though the data is held by a third party, the government still needs a warrant to obtain it. We decline to grant the state unrestricted access to a wireless carrier's database of physical location information, said Roberts, writing for the majority. In light of the deeply revealing nature of cell site location information, its depth, breadth, and comprehensive reach, and the inescapable and automatic nature of its collection, the fact that such information is gathered by a third party does not make it any less deserving of Fourth Amendment protection. The court made the ruling in the case of Timothy Carpenter, who was convicted in 2013 of robbing Radio Shack and T-Mobile stores in Michigan and Ohio. In order to build their case, the FBI obtained 127 days' worth of location information for Carpenter's cell phone, almost 12,900 location points, which they used to place him at the scene of the robberies. So that's good, man. Very simply, they're saying, get a warrant. Oh, you think that there's a criminal who maybe or maybe not did something? Get a warrant. Go to a judge, get a warrant, then you can look at the records. And I really think it's such a disingenuous argument that was made originally, because they said, oh no, we don't need a warrant because it's a third party that's holding the information. So the fuck what? I mean, so what are you saying? Are people supposed to be the only people that have access to their own cell phone data in order for them to have the right to privacy of it? Like, no, everybody has a cell phone, and it's made by a cell phone company, and their data, they don't have access to all of their own data. They don't have it. So obviously, almost by definition, the company you contracted with is going to have that information. This idea that like, well, no, since a third party holds it, therefore we're allowed to, whatever, look through it without a warrant. I mean, think about that in a slightly different context. Let's say you're with your family and it's your car. And you say, you know what, go ahead, I'm going to lend you the car to go to the store and pick something up. You say that to your mom. So your mom hops in your car and goes to the store to pick up some food. And then she gets pulled over. And then the cops go, oh, we see this is your son's car. Since you're driving it, now you don't have a right to privacy. So you don't get a protection from unreasonable search and seizure. Now it's perfectly legal for us to look through every little nook and cranny and inch of this car to try to see what's in it. Because you don't have a Fourth Amendment protection now because it's not your vehicle. The fuck are you talking about? There's a reasonable expectation of privacy when it's your thing. You're in that car. It is your car at that point in time, even though your son owns it. The fuck are you talking? It's such a disingenuous argument. Oh, they're not your cell phone records because it is held by the company that you contracted with. Shut the fuck up. I can't believe this is a 5-4 decision. I mean, what a joke. What a joke. 4 people were like, yep, that sounds reasonable. You have no right to privacy. It's because it's the third party that holds it. So everything you've ever put online, the government can go look at it. Even if it's on the back end of a company you made a deal with where you give them whatever, your credit card information, driver's license, whatever, I don't care, money, the government can then step in and go, no, we have access to all of that. No, I didn't make a deal with you, bitch. I made a deal with whatever company. I didn't make a deal with you. You got nothing to fucking do with this. Fuck off. I didn't give you the right to look at the shit I just put in there. Who are we What a joke. What a joke. What a goddamn joke. It's a disingenuous argument. I can't believe 4 people fucking fell for it. But by the way, the sad part of all this is, okay, so yay, we have one small win for privacy. We still have the Patriot Act in effect. We still have NSA collecting everybody's metadata and storing it at a multi-billion-dollar facility in Utah. We still have rampant abuse. Edward Snowden shed light on all the abuses, how you have people looking at what their exes were doing, people who work for the government spying on their exes and shit like that. So, hey, perhaps the whole system is unconstitutional. Perhaps all of this data collection without consent is exactly that. Data collection without consent, which strikes me as pretty goddamn unreasonable. It's a pretty unreasonable search. It's a pretty unreasonable seizure. So, get a goddamn warrant. Get a warrant, get a warrant, get a warrant. They used to be called police work. That's what that used to be called. But now it's expected, like, no, the default position is you have to give me everything ever about you. And I'm entitled to that as the government. Or not. Or not.